you were going to get 100% return, a 6-month transaction where you weren't even using your own money.
No, and I also never charged him anything.
Well, you charged him $18,400. Are you aware of the usury law?
I am now. I was not at the time of my dealings with Mr. Murphy.
Do you recall Judge Clark saying, is it reprehensible behavior? Did he take advantage of someone who's desperate? Absolutely.
That's a petitioner versus Lester William Cole. Respondent, case number 10DB 2023, attorney registration number 308109 from Mercer County. We are continuing with petitioner's case.
And you don't have an account at Penn Star Federal Credit Union, correct?
I do have a personal account at Penn Star Federal Credit Union.
All right, is that check from your personal account at Penn Star Federal Credit Union?
No.
That check is from Jenny Laszlo's account at Penn Star Federal Credit Union, correct?
Yes.
Did you tell Mr. Murphy while you were in the Aldi's parking lot that the source of the funds to satisfy his mortgage was actually coming from Jenny Laszlo, not you?
No.
And when you were, did Ms. Laszlo obtain the check and then give it to you?
Yes.
At that time, did you have any written agreement with Ms. Laszlo regarding, were you borrowing the money from her?
I was.
Right. Do you have a written agreement with her at that time regarding the terms of that loan?
No, it was an oral agreement between Ms. Lazo and myself.
What were the terms of that oral agreement?
That she would be repaid when Mr. Murphy repaid me.
Was there an interest?
No, I've known Ms. Laszlo at that point. It would have been probably for 8 years, shared an office with her for several of those.
It's a promissory note dated March 5, 2021. So that's the day you were at the Aldi's parking lot, correct?
Yes.
It's for $36,854, correct?
It is.
And that's exactly twice the amount that was on the check ODC Exhibit 5, correct?
Yeah, that's what Mr. Murphy had offered.
All right. And he was going to pay you double what he borrowed in 6 months, September 7, 2021, correct?
I object to the form of the question. Mr. Murphy didn't borrow $18,437.
Could you rephrase?
How much money did you loan Mr. Murphy?
I didn't loan Mr. Murphy anything. I paid the sheriff's sale off.
Okay. So in exchange for paying the sheriff's sale off in the amount of $18,427 and change, Mr. Murphy agreed to pay you $36,854.72 in 6 months, correct?
So two things. I wouldn't say he agreed. It was his proposition. And he actually asked for 3 months, and it was my suggestion to do it for 6.
And on this copy, the witness is Jenny Laszlo, correct?
Yes.
So, but Jenny Laszlo was not there to witness Mr. Murphy's signature when he signed this in the parking lot of Aldi's on Friday, March 5, 2021, correct?
No, Ms. Laszlo inadvertently signed that when Mr. Murphy came to the office on March 19th, and there were papers floating around the table and she was notarizing the deed and mortgage.
Did you mark anywhere on the document to note that Ms. Laszlo signed it on May 19 instead of March 5, which would be the date that Mr. Murphy signed it?
No.
Okay. We can agree that no one witnessed Mr. Murphy's signature other than you on March 5, correct?
Yes.
And then you were going to use $18,427.36 to pay back Ms. Laszlo, correct?
Yes.
And you were going to keep the remaining $18,427.36, correct?
Yes.
All right. And what were you going to do in order to earn that additional $18,427?
I don't know how to answer. I mean, it's a mortgage. It's a promissory note. You pay it back.
And did you tell Mr. Murphy what you're going to do with the paperwork that he signed at the Aldi's parking lot?
I mean, I told him I would send him a copy of it, which I did.
You didn't give him a copy at the time, correct?
No, I didn't have a copy machine in my car.
He could have signed duplicate originals, right? You're a lawyer.
I object to the form of the question. You can't sign duplicate promissory notes.
If you say so.
Okay.
How long was your meeting with Mr. Murphy in the parking lot of the Aldi's?
As I said, probably 45 minutes or so.
So you were investing in something that you didn't know the value of.
Yes.
And that's because you were going to get 100% return for a 6-month transaction where you weren't even using your own money.
Yeah.
Did you tell Mr. Murphy that there were other investors?
No, there weren't other investors.
You don't consider Ms. Laszlo an investor, even though she's the one that funded the actual money?
No, she wasn't getting anything for her investment, so I wouldn't consider her an investor.
Okay. And just so we're clear, you never had any written fee agreement with Mr. Murphy relating to preparing and serving the motion to enforce marital settlement agreement, correct?
No, and I also never charged him anything.
Well, you charged him $18,400. Now, Mr. Murphy did not pay you the $36,000 by the September 7, 2021 deadline, correct?
Mr. Murphy never paid me a penny at any time.
Yes, you did not agree to accept less than the $36,000 in the promissory note, correct?
The day
To the
he,
form of the question, he agreed to modify the time for payment and the amount of payment, arguably less than what was originally agreed to.
But you're testifying for him. I'd like to hear him and say that.
Mr. Cole. And so when you quit-claimed the deed back to Mr. Murphy on August 9, 2023, it came with the encumbrance of the new mortgage of August 1, 2023 on behalf of Jenny Laszlo, correct?
yeah, it put Mr. Murphy in the exact position he was in before he had ever called me in December of 2020, minus the foreclosure on the home.
No, not precisely. He also now has a mortgage against his property that he didn't have before he called you.
But the topic of the loan, you didn't offer the loan money, Mr. Murphy. Murphy asked you to loan him.
Oh, yeah, I don't have money to loan people, number one, and then I would probably be seeking a divorce attorney if I did.
Was there a discussion about the loan amount at this time?
He said, I'll pay double.
And what
I
prompted
mean, that was his quote.
is to say that?
There was no prompting. He asked if I could, I guess he asked if I could loan him the money. I said, I don't know that I can come up with the money. And he said, well, I'll double the amount that you're loaning me.
And that was his idea.
Correct. When Mr. Murphy was in the office the first time on March 5th, as he left, and I don't remember the exact comment I made to her, was that he needs a lot of money or his house is going to be sold on Monday. And Jenny's quote was, I don't want the guy to lose his house. How much is the loan for? And then she made that happen. If that wouldn't have happened, he would have lost the house at the sheriff's sale on Monday.
Was that somewhat enticing or appealing to you?
Certainly.
So what did you do after that third call?
I first went to the disciplinary rules, and again, I don't remember what rule it is off the top of my head. Read it. My interpretation again was, if you are an attorney, you cannot enter a business transaction with a client unless these conditions are met. So I read the rule. I thought, okay, I can do this because I didn't consider him a client, number one. So I thought if I followed the rule, it was going to be an added layer of protection for myself in the event someone determined I was actually acting as his attorney. And then I determined what else would need to be done to complete the transaction, which ended up being the mortgage, the deed, and the promissory note.
In telling Mr. Murphy about everything you had to do, were you trying to persuade him to enter into this transaction? Or were you hoping all the complications might dissuade him?
I mean, obviously there was incentive there for me if he agreed to do it, but frankly, I would have preferred to not ever hear from him again. I drafted this letter, again, when I reviewed the disciplinary rules on entering business transaction with clients. I don't know the rule verbatim off the top of my head, but the rule essentially says an attorney shall not enter a business relationship with a client unless, and then there are a list of things that have to occur before that business relationship is entered. I did not feel that Mr. Murphy was my attorney, that the rule was applicable to
Was your attorney or your
that I was his attorney, I'm sorry, that I was Mr. Murphy's attorney. However, in an abundance of caution, at least in my mind, I wanted to follow the rule in the event he was determined to be a client of mine. So that's what the third paragraph of this, I mean, the letter, the purpose of the letter was to comply with that rule.
Did you meet Mr. Murphy at the parking?
Yes, he was parked in the back corner of the parking lot.
Tell me how that meeting took place.
I mean, I had my documents, I had a clipboard. It was freezing out. I remember it was snowing. But I pulled up, I parked, I got out of my car, he opened his door and stood up. I showed him the check. I had the clipboard with, I only had him sign the March 5th letter and the promissory note at that point. But I said, here's the documents we reviewed. He looked at them quickly again. Everything okay? Yes. He signed and dated. And then I left and went to Mr. Manolis's office.
Now, tell me about, though, the mortgage with Ms. Laszlo. How did that come about?
I mean, it's really, as disciplinary counsel asked me earlier, why wasn't she the one that did this? Why wasn't I out of it? This was probably the right thing to do from the beginning. So, he was back to square one, essentially, except he didn't have a mortgage foreclosure hanging over his head. And now Ms. Laszlo was really in the position she probably should have been in from the beginning rather than me.
Did you pay all the costs and transfer tax associated with this transaction?
Yeah.
That is, Mr. Murphy didn't have to incur transfer tax, recording costs, satisfaction costs, anything. You did.
I paid it all. I think it was a little over $4,000 was the transfer tax.
Those crimes included theft by deception,
Yes,
criminal conspiracy,
correct.
the violation of the Pennsylvania Interest Act. There's another word in there.
Yeah, I don't know what it's called. It was concerning the interest.
Ultimately, we filed suppression motions to dismiss, and the Attorney General's office, the Commonwealth City Attorney General's office withdrew the interest charge. This was over the statute of limitations, and a senior judge in Allegheny County dismissed criminal cases finding no probable cause. Correct?
Correct.
Do you regret having anything to do with Mr. Murphy?
Yeah, certainly.
I have nothing further to say.
Do you live there today?
I do not.
Why not?
Lost my house tax sale.
Who owns your house today?
The secretary, or the person that does the work at his office, at the attorney's
I
office.
object to the form of the question.
What's the objection?
He didn't ask anything about who she is. He just asked who owns it, not identifying the person in terms of where they work.
Well, that was the testimony of the witness. That wasn't, it didn't have anything to do with the question.
Well, then we move to strike the answer as non-responsive.
Oh,
Is it Jenny Laszlo?
Yes.
Did you buy the house at 644 Old Mercer Road?
I did not. I billed it.
Did he tell you where he got the check?
No, he did not. He was very evasive about where the money was coming from.
Did he tell you that he had borrowed the money from Jenny Laszlo?
He did not.
Did you know that he had borrowed the money from Jenny Laszlo?
I did not.
Did Mr. Cole give you any papers to sign?
Yes,
Had you seen those papers before the parking lot meeting?
I had not.
At the parking lot meeting, did you discuss with Attorney Cole interest on the loan he was making to you?
Briefly.
What do you recall being discussed?
He pulled out the paper and said that he had the loan paper and he was going to loan me the money, but he needed to double it because of where he had received the money from, but he did not say where he received it.
Is it your testimony that he was the first one to mention doubling the amount?
Yes, correct.
Did you ever suggest that Mr. Cole, you would pay him double if Attorney Cole loaned you the $18,000?
I did not. I was shocked when he mentioned that.
And this letter, it says that After our discussion, we have agreed that you have not been, nor will you become a client of my legal practice. To the contrary, you have requested that I enter into a private personal agreement with you whereby I will act not as an attorney, but as an individual investor. Do you see that?
Yes.
Okay. Who suggested that Attorney Cole act as an individual investor rather than an attorney? You or he?
Had to have been him because I didn't know anything about that.
At any time, did Mr. Cole tell you that the $18,427.36 that was being used to satisfy the mortgage was not his money, but some other person's money?
No.
And when you signed this, had you agreed to pay him essentially twice the amount owed on your mortgage? 36,000 instead of 18.
I had to agree
Why?
because it was limited. I mean, there was only 10, 15 minutes till the attorneys were going to close and the house was going to be sold on Monday.
Prior to that parking lot meeting, did Mr. Cole ever identify himself as being an investor as opposed to a lawyer?
He did not.
How long were you in that parking lot with Attorney Cole, if you recall?
5, 10 minutes maximum.
And in that time, he showed you those documents and you reviewed them and signed them?
Correct.
Did he leave you with any papers?
He did not.
Did you ask him to give you copies of those papers?
I did.
What did he say?
He said he'd have them to me as soon as possible. The following week, definitely.
Did he later send you copies?
He did not.
All right. How were you going to get the money to pay him?
By the sale of my mother's house.
Was that property already on the market?
I believe it was at that point.
And that appears to be the settlement statement or closing statement for the sale of your mother's property on September 15, 2021. Does that comport with your recollection?
Yeah.
All right. So it says here, is this accurate? The sales price was $87,500?
I believe.
All right. Then there were some costs attributed to you. Also, the mortgage of $37,346 was paid off. And then on page 3 of 4, it says due to seller on the left-hand side, $33,128.66. You see that?
Yes.
All right. Did you walk away with a check in your hand on September 15, 2021, made payable to you in the amount of $33,128.66?
I did.
So you walked out with $33,000 and change, but you owed Mr. Cole $36,800, correct?
Correct.
Did you ask him to accept less than the $36,000 to satisfy the note and the mortgage?
I did.
How much did you offer to pay him?
I believe $25,000 is what I offered.
Did he accept that?
He did not.
What did he say?
He said that he needed the full amount.
You had not paid a single penny of any amount of any money, whether to Mr. Cole or anybody else, for the $18,427.36 was paid on your behalf to take your property at 644 off the sheriff's list for May 8, 2021. Isn't that correct?
Correct.
And in fact, your position was you don't believe you owe anybody any money out of that transaction. Isn't that correct?
Correct.
That is, other people were responsible to pay your debts you incurred on your own and led to the foreclosure action. Isn't that correct?
No.
Well, did you ever take responsibility and make any payment of the $18,427.36?
I tried to make a payment of it.
That you did not.
I did not.
If that amount hadn't been paid, you would agree with me on March 8, 2021, your house likely would have been sold, not like that your house was gone, I think was your testimony as of March 8, 2021, correct?
Correct.
And then the bank would have filed an ejectment action against you to force you out of your home, correct?
I have no idea.
You think the bank was just going to let you live there for free?
I don't know what their policies are.
You didn't pay the taxes, did you not?
I did not.
And that house went up for tax sale, isn't that correct?
Correct.
Did you go to the tax sale?
I did not.
Ms. Laszlo, as anybody could have done so, purchased your house at tax sale, isn't that correct?
Correct.
Now, when she purchased the house at tax sale, she owned your house, isn't that correct?
At some point, yes.
It said, I then met Attorney Cole on the side of the street, a block or so away from his office. Did you meet him outside his office, a block or so away? Well, you were asked previously how Ms. Laszlo had a copy of your driver's license. You said you had no idea. You told the trooper you were never there. And if you weren't there, then it would be impossible for you to give your driver's license either Mr. Cole or Ms. Laszlo.
Well, I'm not sure when I gave my driver's license to them.
Could have been in what? January of 2022?
I have no idea.
No idea. The time you were testifying at the habeas corpus proceeding, that it was your attempt to sell your mother's house.
It was my mother's house.
Who owned it?
I owned it.
Now, you owned it. That means it's an asset of yours, correct?
Correct.
Did you ever testify or did you ever tell anybody you really didn't have assets or had no assets?
Say that again?
Did you testify or tell Trooper Morris you didn't have any assets throughout this time you were dealing with Mr. Cole?
Not that I recall.
It's involving the criminal case involving Miss Laszlo. Do you recall that?
Yes, I do.
Turn to page 25. And this is from the Deputy Attorney General asking you on direct, did you have any other assets in your name other than your home? And what was your answer?
No.
You'll acknowledge that that is a false testimony by you, correct?
I do not.
Huh?
I do not.
You didn't own your mother's home at that time?
In 2024, no, I did not.
She's asking if this is relating to your time when you were talking.
He sold it 2 years earlier, sir.
You're both right. What you're having him relay is what his testimony would have been, what he was talking about when he met with Attorney Cole in March.
The testimony related back to March of 2021.
Right. Not like I'm saying, you're both right. He didn't own the house at the time of the testimony, but what he was relating back in 2021, he did own the house. We understand that.
Now, when you saw Mr. Cole in December, you knew you were behind mortgage payments on the house in Newcastle, correct?
I would imagine I do.
And you didn't mention that to him, did you?
I don't recall.
How about on March 5, 2021, when you showed up at his office? Did you mention that the proceeds that you were going to pay to him to satisfy the loan was for property that was also being foreclosed on? Or you don't remember that either?
I don't recall.
You don't mention that to Trooper Morris either, correct?
I don't recall.
And he also asked that you add him as an additional insured on your insurance policy and provide proof of that. You see that?
Yep.
Did you ever do that?
I did not.
Did that cost you any money to do that?
It would cost me amount of insurance.
To add him as an additional insured?
I didn't have insurance at the time.
Oh, you didn't tell him that, did you?
He didn't ask me.
So you had no homeowner's insurance.
I did not.
Mr. Cole wants to be added as an additional insured, and at no point did you tell him, hey, I can't do this because I don't have any insurance on it.
I'm not sure of that.
Mr. Murphy, have the opportunity to look through your bank statements from Westco Bank.
I looked through some of them, yes.
And would you agree with me that you deposited $25,000 and change in September of 2021?
It was $28,128.
Have you found transactions in there where you were paying taxes?
I did not, but I'd have to look closer.
Did you find any transactions you were paying pre-existing debts?
I did,
Which debts were those?
for moving expenses,
Okay, how much was that for?
$750.
Okay, all right, what else?
You said there was nothing. There is in here.
I don't know if I said nothing, but I said,
You said there were nothing.
okay, well, you can look through them, sir.
Without looking through the entire thing and going in it, it would take me several hours.
Would you agree with me, the bulk, if not the overwhelming majority of that 28,000 that you deposited from the sale proceeds, all are debited on that account by the designation POS with the name of a business, such as a restaurant or a clothing store?
A lot of them are.
As to that debt, that payment, that $18,427.36, that was the principal amount of the loan. And whether we had doubling or not doubling, you didn't pay any part of that principal, correct?
Correct.
You didn't pay it to Mr. Cole during your transaction with him, and you didn't pay it to Miss Laszlo when she had a mortgage on your property after August of 2023, correct?
I paid neither one of them.
Let me get to the point. Does it not say here that the sheriff's sale is scheduled for March 8, 2021?
Correct.
Cole knew that on December 31, 2020.
Yes,
All right, so he knew it wasn't in January or the next day, correct?
as far as I know.
All right. So as far as you know, Cole knew in December
Correct.
and had communicated with Attorney Manolis apparently throughout January and into March of 2021 regarding how much was owed, correct?
Correct.
No further questions.
Mr. Murphy, tell me, what difference does it make if the money came from Miss Laszlo or not? No difference, correct? The money was used to satisfy your first choice federal credit union judgment against you, whether Mr. Cole got it from his own account, borrowed it from Miss Laszlo, took it out of his kid's college account. Did it matter to you where that came from?
At that point, it did not.
Would it be safer to assume that you never had an agreement with him for him to loan you money in December because he hadn't done anything for almost 3 months?
No, it would not.
I have nothing further.
Thank you. Thank you, sir.
Thank you.
ODC rests. Next sentence, to the effect, I am enclosing a copy of the deed to the premises, which is subject to a mortgage payable to Jenny Laszlo for the original amount of money that was loaned to you in the amount of $18,427.36, plus interest at the lawful rate of 6% per annum, which carries a payment date of December 2024, a copy of which is also enclosed. I read that correctly?
You did.
All right, who chose the wording lawful rate of 6% per annum?
That's the interest rate that's allowed to be charged with.
You are a criminal defense attorney by experience and trade.
Yes.
You are aware that 100% interest is not lawful,
Well,
correct?
object to the form of the question calls for a legal conclusion too. That's it's speculation without foundation. He wants to call an expert as to the Loan Interest Act. He can. That's not a correct statement of the law nor a correct question. Lacks foundation and it calls for speculation.
Sustained.
Are you aware of the usury law?
I am now. I was not at the time of my dealings with Mr. Murphy.
So is it your testimony that in March of 2021, you did not believe 100% interest to be illegal?
That's correct. And I would note, I believe that charge I'd have to look back at the criminal complaint to be certain, but I don't think that was charged under the crimes code. I think it was another title.
We're not here for crimes. We're here for disciplinary matters. Do you understand that?
And you're asking me if I knew if something was illegal or not. I'm indicating it's not in the crimes code.
And that is a mortgage in the principal amount of $18,427.36, correct?
It is.
All right. It does not mention 6% interest, does it?
It does say together with interest thereon at the rate payable in the note,
It does not say 6% interest, correct?
not specifically.
It refers to the note, correct?
Yes.
And the note is not attached to Exhibit 21, correct?
I don't see it.
Okay. But we have the note as ODC Exhibit 23, correct?
Yes, that's it. It indicates 6% per annum.
Who chose 6% for the note?
As I said, after I learned later, that's the lawful interest rate, so that's the interest rate that was used. What I did by the note and mortgage was put everyone in the position that they should have been in from the beginning, including Mr. Murphy, whereby the $18,427.36 mortgage from myself to Ms. Laszlo is the identical amount that she paid in the first place to save Mr. Murphy's home from sheriff's sale. She should have been on the mortgage in the first place. So the mortgage and note, in my mind, put everyone back where they should have been to begin with.
Taking out your $18,427.36 of anticipated profit.
Yeah, that would be putting everyone back in the position.
Apparently, I don't understand real estate transaction, but I guess you're not a practitioner of real estate transaction either, correct?
Correct.
So either one of us, if we decided to practice in real estate, it would behoove us to exercise additional care to make sure that we got it right, since it's not our area of expertise, correct?
In the future?
And in the past,
Sure.
right? Because the rules require competence in anything you do, not just in your specialty, correct?
I believe so, yes.
Now, would you describe Mr. Murphy as an unsophisticated person?
It doesn't seem like it to me based on his behavior over the last several years. He seems very sophisticated.
And as of at least May 14, 2021, you were acting as Mr. Murphy's lawyer.
Is that a question or a statement?
It's a question.
Okay.
Is it true that as of May 14, 2021, you were acting as Mr. Murphy's lawyer?
I was taking legal steps on his behalf, but in my mind, I was not acting as his attorney. I was acting in an effort to, get his wife off the deed, which I guess I could see that argument, but to assist him in what we were trying to do with the mortgage or with the land house.
In your mind, taking legal steps is different than being a lawyer or acting as an attorney?
No.
And as of May 14, 2021, you had no written fee agreement with Mr. Murphy, correct?
As I stated multiple times yesterday, I had no fee agreement with Mr. Murphy. I never charged Mr. Murphy anything. He never received a bill from me. Mr. Murphy said he only had $25,000, which I learned later. He said that's how much he received, and then learned later that he received more than that.
33.
So he was lying to me once again at that point.
And so now, knowing what we know now, that he told you that he didn't have insurance, you still agreed to go forward on the transaction to loan him $18,000, to use $18,000 you borrowed from Ms. Laszlo in exchange for him paying you $36,000 in 6 months, despite the fact he didn't have insurance on the property,
Sure.
despite the fact you knew he wasn't making his mortgage payments.
I don't think there were mortgage payments to make at that point. The house had already been foreclosed on.
Okay.
Yeah, did he file anything, challenge anything for?
Oh, no, the only thing, I filed my complaint in ejectment. As I said yesterday, the sheriffs were unable to serve him. I had to serve him by publication, and then he ultimately defaulted.
We do object, I think there's a certain purpose to the transcript. I don't know what Judge Clark's comments have to do with anything. Her ruling is what's important. What's important is that you had a trooper that ignored the law, you had a trooper that ignored his duties, ignored evidence, and people filed charges that were unwarranted and couldn't be sustained at a probable cause level. That is an embarrassing low burden of proof for a prosecutor to make, and to fail in that regard just shows and underscores the weakness of the allegations, and some of them are just absolutely incredible. It's the ruling that's important, not Judge Clark's comments. She's not an expert. This board is the one that's hearing the evidence. It's the hearing both sides of the evidence. And there's things that were not admitted in the habeas corpus that were admitted today. They just certainly weren't relevant. So I don't think her comments are relevant. I don't think that's...
Well, the committee will have the opportunity to weigh the weight of the evidence.
And that's fine.
I'm going to overrule it, and with the expectation that we're not just picking out pieces of it, we're actually getting the full transcript, which is what we asked for in the originally. So, I'm going to admit that, and if it is admitted, then you have the opportunity to use your admitted evidence to ask questions.
Do you recall Judge Clark using the phrase win-win with respect to you in the transaction?
I don't remember what she said. Whatever the transcript says is what the transcript says.
I'm asking you for your recollection.
I don't remember.
Recall her saying Mr. Cole set himself up for a win-win situation.
Again, I don't remember what the judge said. If it's in the transcript, then that's what she said.
Do you recall Judge Clark saying, is it reprehensible behavior? Did he take advantage of someone who's desperate? Absolutely.
I do not recall specifically what Judge Clark said. If it's in the transcript, I'm not denying that she said it. Whatever the transcript says is what she said. I don't specifically remember every word that the judge said, no.
What did you talk to him about with respect to what is fair and reasonable?
I explained to him fair and reasonable would be both parties receiving some benefit. And I mean, his comment was, well, it's fair, it's my idea. That's why that language is included in the letter.
Do you think you have an obligation as an attorney to make a decision on whether or not terms are fair and reasonable? Or do you just rely on the opposing parties to say?
No, I wouldn't rely on an opposing party.
Do you think that you ever did any legal work for Mr. Murphy?
Yeah, I mean, obviously the correspondence with Attorney Barletta in April and in May, I would say yes.
Do you think that that makes Mr. Murphy a client of yours?
At that time, clearly, yes.
And that all postdates the transaction?
Yes.
Attorney Cole, my name is Jason Medora. I just have one question, and I know it's been answered by you in your response to the original petition. Do you believe you violated any rule of professional conduct when you offered a loan to Mr. Murphy that would have given you 100% return on interest?
I don't. I believe I followed, again, I can't recall the rule, but I believe I was in accordance with the rule regarding business transactions.
Do you believe that there was any rule that you may have violated in relation to you charging 100% interest on a loan?
I honestly would have to review the rules. I don't want to answer that as an outright no. I would have to look back at each and every one.
Okay, so wait a second. Because he didn't pay you any money, are you saying that you didn't violate any rule as a result?
No, I was answering his.
Well, your attorney just said, would it be a different case if he would have paid you back? So I'm wondering, does your thought process have to do with, I didn't do anything wrong because I never got paid anything? Or I didn't do anything wrong because the document I originally created didn't cause me to do anything wrong? If he paid you the full $36,000 plus in the mortgage and promissory note, at that point, do you believe you would have violated any rule of professional conduct?
I think that relates back to your earlier question. Again, I would want to look. I think what I was saying was if I had collected all of that and not refunded, et cetera, that if it's possible to be in a worse situation than I am, that I would.
That's already?
Yes.
All right, we can go back on the record. The committee has confirmed, and we find at least one rule violation that has met the prima facie burden of evidence.
Statement showing the dates, general nature, and ultimate disposition of every matter involving the arrest or prosecution of respondent attorney during the preceding 10 years.
Yeah, within the last few months, Trooper Morris had decided to file additional charges against me.
They are currently pending.
Correct.
No disposition, however.
No.
Not related to Mr. Murphy.
No.
I have no other evidence relating to the level of discipline.
Okay, so we need to set a briefing schedule.
The respondent has no other evidence.
I can place the briefing schedule on the record.
Yeah, should we go off the live?
Yeah, we can go up the live stream.